In the previous 4 sessions, we've covered the first 4 articles of the Constitution, and now today we'll accelerate and finish the Constitution with Articles 5 through 7. First of all, um, Article 5 starts out with amendments. So the founders are recognized that changes must be permitted in the Constitution. But they also realized that the process shouldn't be easy because a constitution should have stability to it. I was amazed when we moved to California how easily the California Constitution could be changed. One referendum question comes up for a vote, people vote on it, maybe not very informed, and if it gets a simple majority, okay, it's a new part of the Constitution, California. But the U.S. Constitution, they wanted stability to it, so they didn't want it to change very quickly or easily. And they wanted proper deliberation and broad support. So the Fifth Amendment reads, the Congress, whenever 2/3 of both houses shall deem it necessary, shall propose amendments to this Constitution, or on the application of the legislatures of 2/3 of the several states, shall call a convention for proposing amendments, which in either case shall be valid to all intents and purposes as part of this Constitution. So when I use the Brown text, that's a direct quote from the Constitution. So amendments are proposed by either 2/3 of both houses of Congress, so the House and the Senate, 2/3 of each of them would have to vote for an amendment, or 2/3 of the state legislatures would have to call for a convention to propose amendments. So 2/3, right now we have 50 states, so that's currently 34. A convention has never quite been called. It's gotten close several times. So it's a little bit uncertain exactly what its scope and operation would be. Would it be limited to a specific purpose or just open-ended to propose any amendments? That's never quite been clarified because it's not been done. Several times the call for a convention was close enough that Congress was pressured to act before a convention was called. So it's like a state or two short, and Congress said, okay, we'll go ahead and propose this convention, or propose this amendment rather than having a convention. Possibly because they're not sure quite what would happen. Maybe a convention would start proposing more things. So I thought it was better to just propose the one amendment and go forward with that. So it continues that when ratified by the legislatures of 3/4 of the several states, or by conventions in 3/4 thereof, as the one or the other mode of ratification may be proposed by Congress. So ratification takes 3/4 of the state legislatures, or 3/4 of conventions in the states. So 3/4 of our states is currently 38. So they do these as fractions so that the American colonies started as 13 original states, and we've expanded to 50. But because they use fractions, the number grows as the number of states grows, and they don't have to go back and change the wording. So 3/4 of the states is a large majority, large supermajority. And this requires that there be very broad consensus to make any change to the Constitution. So far, the amendments that we've had have all been ratified by the state legislatures, except the 21st Amendment, which was the repeal of prohibition on the manufacture and sale of alcohol, which was passed by state conventions. All the other amendments have been approved by the state legislatures. And it says that Congress can choose the mode of ratification, whether state legislatures or state conventions. So more recently, amendments have often been proposed with time limits, typically 7 years. Although the 27th Amendment, which is the most recent amendment, was proposed in 1789 and not ratified until 1992. So over 200 years later before it was actually ratified by the required number of states. Of course, the required number of states went up quite a bit in those 200 years. So we have the supermajority requirement to gain broad support for any constitutional amendment. And this amendment article was used immediately after approving the Constitution to add the Bill of Rights, which was used to satisfy the Anti-Federalists. The Anti-Federalists were against the Constitution, passage and ratification of the Constitution. But because of the addition of the Bill of Rights, they were satisfied that people's rights would be protected adequately. So then they were willing to support the Constitution. An additional sentence or two here on the amendment clause article says, provided that no amendment which may be made prior to year 1808 shall in any matter affect the first and fourth clauses in the ninth section of the first article, and that no state without its consent shall be deprived of its equal suffrage in the Senate. Okay, so why 1808 and what's the fourth clause of the ninth section of the first article? So basically they were saying for 20 years after this was approved, that this precluded any amendment from preventing the importation of slaves or the changing the direct taxing per head. So this was put in to satisfy southern states that slavery, importation of slaves wouldn't be outlawed for the next 20 years because there was enough movement against slavery that the southern states were worried that the northern states and maybe a few southern states would gather together and say importing slaves is outlawed and their economies would be wrecked. So they didn't, they weren't willing to approve the Constitution if that was the case. So to give them protection for their economies, which were based on slavery, they had this put in. And in 1787, actually only North Carolina and Georgia permitted the importation of slaves. So they thought we're the only two, the other 11 could outvote us and say, oh, no more importation of slaves. So they prohibited regulating that for 20 years. So 20 years later, March 2nd, 1807, Congress voted to outlaw the slave trade, the importation of slaves from overseas, as of January 1st, 1808. So that was the first day that they could do that. And they passed the law in the previous March. So it would take effect as soon as possible in 1808. And this was a few weeks before William Wilberforce persuaded the British Parliament to do the same. And only Denmark in 1792 had been earlier in this. So America was the second country in the whole world to outlaw the importation of slaves from overseas. So this was the beginning of the abolitionist movement. And it was a big enough deal when the Constitution was being drafted that some of the southern states were worried that, oh, this is going to move forward and outlaw this. So so definitely the abolitionist movement was proceeding and was a movement at this time. And we see that, you know, Congress 20 years later did act as soon as possible to outlaw the importation of slaves. Now, that didn't prohibit trading of slaves domestically. So it wasn't, you know, just outlawing slavery overall. That waited till after the Civil War. But importing slaves, say from Africa, was outlawed at this point. So Denmark, America, and Britain were the first countries in the world to do this. And the last sentence here, that no states without its consent shall be deprived of its equal suffrage in the Senate, indicates that states are an integral part of the Constitution and their equal representation in the Senate can't be changed without their consent. So presumably no state would say, oh yeah, I don't need a vote in the Senate, or you can give me one instead of two. So this protects all the states, even the small ones, from losing their representation in the Senate. So that was Article 5. Moving on to Article 6, it says all debts contracted and engagements entered into before the adoption of this Constitution shall be as valid against the United States under this Constitution as under the Confederation. So prior to this, America was under the Articles of Confederation. So that's the Confederation that's referred to here. And during the Revolutionary War, debts were incurred by the Continental Congress and later by the Confederation Congress. And this is saying that those debts will still be honored under this Constitution. We're not changing our government to get out of our debts or to say, oh, tough luck, that was with the old arrangements, that doesn't apply anymore. So this reassured the domestic and the foreign bondholders that they would be paid back properly. and it helped give our country a more solid financial footing. Article 6 continues with the Supremacy Clause, which reads, "This Constitution and the laws of the United States which shall be made in pursuance thereof, and all treaties made, or which shall be made under the authority of the United States, shall be the supreme law of the land. And the judges in every state shall be bound thereby, anything in the Constitution or laws of any state to the contrary notwithstanding." So this is saying, okay, the states and the federal government can both make laws in the same areas, same areas of behavior and such. So there needs to be a way to resolve these conflicts if they arise between these. So this clause says both are free to pass laws, but if there's a conflict between them, the federal law shall prevail. There were a couple other ways they could have dealt with this. They could have said states can only pass laws in a certain area of influence, and federal government can pass laws in other areas, so that their jurisdictions wouldn't overlap. Or that the federal government could have a veto over state laws, and that was a proposal that was debated. But they decided to allow both states and the federal government to make laws, as they saw fit. But then if there's a conflict that arises between them, then that can be adjudicated in court, and the court can decide, yes, there's a conflict here, and the federal law should prevail. So this states that there's three elements of supreme law: the Constitution, federal laws, and treaties. So because Constitution is listed first, you could argue that this is the most important. And that's what the Supreme Court did in the famous case Marbury versus Madison, where the Supreme Court said we have the right to review laws and see if they fit with the Constitution, or if they're unconstitutional and should be thrown out. So the Constitution is of primary importance, and secondary would be the federal laws and treaties. As it's come to be adjudicated in the conflict, they say that the most recent thing passed would take precedence over something that was passed longer ago. But still, the federal would take precedence over the state. Article 6 continues with the Oaths Clause. The senators and representatives before mentioned, and the members of the several state legislatures, and all executive and judicial officers, both of the United States and of the several states, shall be bound by oath or affirmation to support this Constitution. So this requires all federal and state officers to take an oath to uphold the Constitution, which creates a personal obligation on each of these officials to support the Constitution. So they're not, oh, I'm a state official, I don't need to care about the Constitution. Even state officials are required to take this oath to uphold the federal Constitution. Often people add, "So help me God," because as an oath, it's an obligation of the person to God to carry out this commitment. And this was another means of bringing together the various sovereign states into a unified whole, because not only the federal officials, but the state officials were upholding this Constitution to unify us together as a country. In England, people would swear allegiance to the king, and here this is replaced with the Constitution. So this again shows that we have a republic. We're a nation of laws, not a monarchy with our allegiance to the king, or not a democracy either, where our allegiance would be to the people or the majority. Here, the Constitution, our basic laws, are the thing which is ruling our nation. So they say no person is above the law, because our Constitution is the supreme law of the land. So it's an important distinction that we're a republic, not a democracy. We're a democratic republic, but primarily our government is a republic. It says oath or affirmation. So this or affirmation phrase was added for Quakers and others who believed it was wrong to take an oath. According to Matthew 5:34 and through 37, it says, Jesus talking, "But I tell you, do not swear an oath at all." So because of this verse, they didn't want to force people to do something that was against their religion. So they said oath or affirmation. The strength of it, the bond that you're undertaking is considered in both cases to be quite important. But in order to not force people to swear, they said you can affirm instead of swearing. Article 6 continues with a religious test, or no religious test actually. It says, but no religious test shall ever be required as a qualification to any office or public trust under the United States. So initially this applied only to federal office holders, but was expanded by the Supreme Court in 1961 to any public office. So federal and state, local, all public offices. And at the time this was supported because there were many Christian sects within the colonies. We've just heard there were a variety of beliefs through the colonies. So no one Christian sect would be discriminated against because no one sect was strong enough to dominate the government. And they thought if other sects got together against them, they could make a test to exclude any one sect. So everyone thought this was a good idea to say that there should be no religious test. So we don't have a government of all Lutherans or all Catholics or any other sect. We have the federal government should be free of religious tests. And at the ratification, there were arguments that also recognized this would allow non-Christians to hold office as well. And that was debated and generally deemed to be okay. That not only various Christian sects, but non-Christians also could hold office. So this is also, I guess, supported in not establishing a religion in the First Amendment. So there's no one particular religion or any religious test that's required. They're free to exercise religious beliefs or not according to their conscience. So the 7th article is about ratification. So the entire article is just one sentence. So it's the very shortest article in the Constitution. It says, the ratification of the conventions of 9 states shall be sufficient for the establishment of this Constitution between the states, so ratifying the same. So short and sweet, right? But even though it's short, this confronts several problems that they had. First, how to deal with the Articles of Confederation amendment process, the purpose for which the convention was called, as well as the resistance of those who would lose power as a result of this new constitution. So in 1786, the Confederation Congress, which was what was the national government at that time, was the Confederation Congress, called an Annapolis Convention to resolve economic problems of interstate trade due to a multitude of protectionist tariffs. So various states were passing protectionist tariffs, and it was hindering interstate trade. So this was an economic problem. But only 5 states sent delegates, and 4 others were too late arriving for this. It was only a 4-day meeting. Travel was slow in those days, so 4 other delegations were too late to come to the meeting. But this did recommend fixing the underlying problems in the Articles of Confederation. With only 5 delegations, they really didn't figure they had enough authority to do something, but they recommended that we need to fix the problems in the Articles of Confederation. So early the next year, a convention for revising the Articles of Confederation and reporting to Congress was proposed for May 1787, Philadelphia. Okay, so we have revising the articles and reporting to Congress. Well, we got a little beyond that. Only Rhode Island refused to send a delegation this time. So 12 of the colonies, or 12 of the states, were represented. And by September 17th, 1787, so 5 months later, the convention had gone far beyond just revising the articles. And indeed, they were proposing that the Articles of Confederation be thrown out completely and replaced. So they went a little beyond what they were called to do with revising and reporting. So this threatened the very existence of the Confederation Congress and also some of the powers of the states. And so thus they might be less likely to approve this. Usually people don't sign up to diminish their own power. So this was a problem. Okay, we're proposing this new constitution, but why would the Confederation Congress vote themselves out of existence to approve it? Or why would the states voluntarily give up power to approve it. So this was a problem to overcome. And also the amendment process in the Articles of Confederation required unanimous consent of the 13 states. And this was never achieved. So there were no amendments to the articles. They recognized it needed improvement, but because they required unanimity, they were unable to actually make any changes. So Article 7 explicitly rejected this because they didn't require 13 states to approve it. They said only 9 states are required. And the Articles of Confederation were approved in many states only by the legislature. So that gave them maybe less legitimacy because they had been only approved by the legislatures rather than the people. So these obstacles were overcome by appealing directly to the people through the conventions elected specifically to ratify this new constitution. As the founders recognized that sovereignty lies with the people, not in the legislatures. If we go back to the Declaration of Independence, it says, "It is the right of the people to alter or abolish it, their form of government, and to institute new government, laying its foundations on such principles and organizing its powers in such form as to them shall seem most likely to affect their safety and happiness." So we see, in some sense, almost this is a second revolution. It's not a war or a fight, but it was quite revolutionary in changing the form of government that they had. But they appealed back to the Declaration of Independence and to the right of the people, that ultimate sovereignty lies with the people, not in governments or groups of rulers, but the right of the people. So basically, they were appealing back to this Declaration of Independence to say it's the people's right to alter or abolish their form of government and institute new government. So that's the very thing they were proposing. And they proposed that only 9 states needed to ratify it for it to take effect. This was to prohibit a few states from stopping the reform, because it was widely recognized that the Articles of Confederation were falling short of what the nation needed as a form of government. So, but they didn't want like one state to have a veto over all of them. However, no state was forced to join. They each joined voluntarily. So it was only going to be binding on states that joined. So it wasn't like, well, 9 of us voted for it, the rest of you, tough luck, you have to go along. It was the option of each state to join. So New Hampshire became the 9th state to ratify in June 1788, followed by Virginia and New York within a month. So they were up to 11 of the 13 states. So Congress started to prepare for presidential electors, which led to George Washington becoming our first president on April 30th, 1789. So under the Articles of Confederation, we only had a Congress. There was no president. So not until we approved this Constitution did George Washington become our first president. So if you note, April 30th, 1789 was just under 2 years after the convention had started in Philadelphia. So they started debating in May 1787. 5 months later, they said, okay, here's this Constitution we're approving. The various states approved it. And within 2 years, we had completely changed our form of government and started this new government, the new Congress and the new presidency. So pretty amazing transformation within 2 years. The final 2 ratifications, North Carolina was in November 1789 and Rhode Island in May 1790. So by that time, all 13 states had voluntarily joined this new union. So in conclusion, amendments are allowed to the Constitution upon a vote of 2/3 of both houses of Congress and 3/4 of the state legislatures or state conventions. So this is a very high bar. It's very hard to achieve. So among thousands of amendments which have been proposed over our nation's history, only 27 have actually made it through and been ratified. So a very broad consensus is required. It's very difficult to change the Constitution, but not impossible. It doesn't require a unanimous vote of all the states. So it's hard, but not impossible, which is kind of the right balance they wanted to strike. didn't allow regulation of the slave trade was prohibited for 20 years so that they could get all the states to buy into this constitution. And even though they realized later this was going to be a problem, but to get all the states to be willing to approve the constitution, they put this in. And it also addressed economic issues, honoring the deaths of the Revolutionary War and making tariffs a federal domain instead of a state, which was kind of the impetus for this Annapolis Convention, which led to the Philadelphia Convention. So the economic problems was kind of the motivator to get together and make changes they needed. In the federal constitution, laws and treaties are the supreme law of the land. They take precedence over state law. And also that every official needs to take an oath to uphold and defend the Constitution. And proceeding along with the no establishment of religion test, it said, or no establishment of religion in the First Amendment, says no religious test is allowed for holding office. And then Article 7 changed the amendment process from the Articles of Confederation, which cleared the way for this new Constitution to be approved. And now it's the longest continuously active constitution of a nation in the world. So it has endured through more than 200 years, served our nation well.